Money in an Arkansas divorce is divided into three main buckets: property, which are assets and debts; support between ex-spouses or alimony; and support for the children or child support. And each is governed by specific Arkansas statutes and court rules. In this video, I will discuss how money really gets divided in an Arkansas divorce. Not how your neighbor says it works, not what you've seen on television, but how Arkansas judges actually approach the money issue when a marriage ends. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company and held positions as the director of the Arkansas Department of Labor, as well as the executive director of the Arkansas Fair Housing Commission. Now, I'm the managing attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had families deal with this very issue, and I hope this video provides some insight into how I provide my advice, which is different for each and every family. When a couple divorces in Arkansas, the court has to decide three big financial questions. Question number one, how to divide property and debt. Question number two, whether to award alimony. And question number three, how to calculate child support if the couple has a child or children. If you understand these three buckets, you understand 90% of the money side of a divorce. So let's take them in each part. Number one, marital versus separate property. So when you talk about the property issue, it could be the biggest shock of all, because in Arkansas, we are an equitable distribution state, not what's yours is yours and what's mine is mine, and not a pure everything is 50-50 community property state. Arkansas law presumes that marital property will be split 1/2 to each spouse, but the judge can adjust that if the equal split would be unfair. Before a judge can divide anything, the court has to separate the property into two different piles. One, marital property, generally acquired property by either spouse from the date of marriage until the date of divorce, regardless of whose name is on the title. And two, separate or non-marital property, which generally includes property owned prior to the marriage, certain gifts or inheritances to one spouse alone, some personal injury awards, and property specifically excluded by a valid agreement, something like a prenuptial agreement. Marital property is what the court divides. Separate property usually goes back to the spouse who owned it, although Arkansas law does allow a judge, in rare cases, to bring separate property into the mix if that's the only way to get a fair result. But the judge has to explain on the record why they deviated. So practically, when you ask what happens to my house, my retirement, or my business, the real question is this marital, is this separate property, or is it a mix of both? So to learn more about how we assist our clients here with these and other types of legal questions, click the link below and let's get started today. So number two, how the equitable distribution really works. Once the court decides what is marital property, Arkansas law says the default is 50-50, but there's a big asterisk. The division must be equitable, meaning fair under the circumstances, and equal is just the starting point, not the guaranteed outcome. Arkansas law lists factors a judge can use to decide whether to deviate from an equal split. Now, these factors include the length of the marriage, age, health, and station in life of each spouse, occupation, income, employability, and vocational skills of each spouse, contributions to the marriage, including whether they were homemaker or worked outside the home, and federal tax consequences for any property division. If the judge does anything other than a straight 50-50 split, the statute requires the judges to state the reasons for that decision in the final order. Now let's look at a few points the public often misunderstands. Number one, title is not king. Having an account or a house only in one name does not automatically make it separate property if it was acquired during the marriage with marital funds. Number two, debt is divided as well. Arkansas applies equitable distribution to marital debts, as well as credit cards, personal loans, tax debts incurred during the marriage, and are usually treated as marital unless it's clear, unfair, and wasteful by one spouse. Businesses and retirement accounts, number three, are still on the table. Closely held businesses, 401ks, pensions that grew during the marriage could be marital property and divided, sometimes using appraisals or qualified domestic relations orders to split those retirement plans. Equitable does not mean the higher earning spouse always pays, and it does not mean that the stay-at-home spouse walks away with nothing. The judge is aiming for a fair distribution of what was built during the partnership of the marriage. Number 3, let's talk about alimony. Who pays whom and why? After property, the second bucket is alimony, also called spousal support. Arkansas law allows a court to award alimony under proper circumstances, usually to help a financially weaker spouse maintain a reasonable standard of living or to give that spouse time to become self-supporting. There's no fixed formula like there is for child support. Instead, the judges have broad discretion with 2 primary considerations. Number 1, the need of the requesting spouse, and number 2, the ability to pay of the other spouse. Courts then look at secondary factors such as the length of marriage, differences in income and earning capacity, again, the age and health of each party, the standard of living that was established during the marriage, contributions to the marriage, including support, the other spouse's career, staying at home with the children. Now, keep in mind, under Arkansas law, alimony can be rehabilitative, meaning for a fixed period to allow the recipient to get education, training, or work experience, or it can be a long-term or permanent payment in some cases, particularly after long marriages or where the age and health limit the spouse's ability to work. Alimony generally ends if the receiving spouse remarries, either party dies, or the receiving spouse lives full-time with a new partner in an intimate cohabitating relationship, and there are also some other contingencies that the court can consider. Either side can ask later on to modify the alimony if there's significant and material changes to circumstances, major drops in income, disability, or the substantial need of the recipient has gone away. From a planning standpoint, alimony and property division are often negotiated together. One spouse takes more property in exchange for reduced alimony, or vice versa. Call us today here at Big Rock Legacy Law Group and let us guide you through this process. Let us talk about the next issue, child support, and we can talk about the income shares model. This next bucket is child support. It's different in 2 critical ways. It belongs to the children, not the parent. Parents cannot waive child support as a part of the deal because Arkansas courts must protect the best interests and the needs of the children. Since 2020, Arkansas has used the income shares model. And in that model, it combines both parents' incomes. It uses the family support chart to find the basic child support obligation, which takes into account the combined income of both parents and the number of children. It allocates the obligation between both parents in proportion to their income when it's combined. For example, if together you earn a certain amount per month and one parent earns 2/3 of that income, that parent is typically responsible for about 2/3 of the basic support, subject to any adjustments. Now, those adjustments considered by the court can be health insurance or uncovered medical costs for the children, work-related childcare expenses, extraordinary costs like special needs, private schools, and significant extracurricular expenses, as well as parenting time arrangements, especially when the time is more evenly shared. Now, keep this in mind. There is a presumption that the guidelines amount from the chart is correct, but judges can deviate from their chart if they believe that it will be unjust or inappropriate, but the judge also has to explain why those deviation reasons occurred. Arkansas law also treats a change in income of 20% or $100 or more as a material change to justify a modification of child support. Now, while property and alimony are about fairness between the spouses, child support is about meeting the children's reasonable needs in proportion to each parent's ability to pay. So let's put this all together. When a divorce is filed in Arkansas, the court is going to walk through a sequence, whether formal at trial or informal in settlement negotiations. And this is to identify what exists, the assets, the debts, incomes, and the children's needs. 2, classify property as marital or separate and identify the marital portion of mixed assets. 3, start from a presumption of 50-50 division of marital property and adjust only if needed for fairness using statutory factors, explaining any deviations. 4, decide whether alimony is appropriate, how much, for how long, and if it's based on the need and the ability to pay and other relevant factors. And number 5, calculate child support under the income shares model to adjust if necessary to meet the children's need. For anyone facing divorce here in Arkansas, here's some practical takeaways. First, know what you have. Get a complete, honest picture of all your assets, debts, and income. Hidden or undisclosed assets can be addressed by the court and can damage your credibility. Second, understand that fair is the standard. Don't assume you keep your paycheck or your retirement just because it's in your name if it was earned during the marriage. Next, think long-term, not just about monthly payments. Sometimes trading short-term cash for long-term assets or vice versa has tax and stability consequences that should be considered. Next, children's needs come first. Child support is not a bargaining chip. It's a legal obligation grounded in the child's right to support from both parents. The core message is this. In Arkansas, divorce is not about winners and losers. It's about unwinding a financial partnership under a set of rules that aim at fairness and protecting the children. When you understand these rules, from how the court decides what is marital property to how alimony and child support are determined, it puts you in a much stronger position to make informed, strategic decisions during this very emotional process. Make sure you subscribe to our channel to learn more about how we help our clients every day here at Big Rock Legacy Law Group.